Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. If you've been following this channel, you've probably seen some of my earlier coverage of GWACS Armory and their lawsuit with KE Arms, Russell Fagan, Sinistral Shooting Technologies, and Brownells. Now, this is kind of an interesting lawsuit because GWACS Armory is nominally a gun company, but they don't seem to have been in the business of making guns for quite some time here. And they're suing KE Arms, who are actually a gun company at this point. But GWACS Armory is kind of the side company of GWACS Defense. And there's this really heavy association with an anti-gun billionaire who said that he wouldn't really support making guns in future, or at least not on the AR platform. And GWACS Defense is really sort of an anti-gun system. It's a system designed to detect gunshots. So that really raises some questions about what all is going on here. But that's stuff from a previous video. One thing in civil suits is that they tend to sort of start out with the big interesting stuff and then get less interesting over time. This case is an exception because it just got spicy. Let's have a look at one of the recent developments here just so that we can go and follow along with this together and you can see what I mean. So we'll just bring this up here. Now I'm just going to note I made some redactions in this, and these are the reason why I made these redactions. These are public documents, so anybody can go and pull these, but there's a bunch of people who came forward independently as witnesses. And so I redacted their name because I don't know that they really need me putting them on blast, but it's public information. So hopefully I got it all, but if I didn't, yeah. But that's just why I made those redactions. All right. Defendant's motion for spoliation sanctions. Now, spoliation is one of those legal words. You might be saying, what does that mean? Well, it means that you destroyed or lost or, didn't turn over documents that you were supposed to turn over. And this can be a big deal. Civil suits rely on discovery, and discovery essentially is that both sides have to turn over any relevant evidence. You can't hide that evidence and then just sort of rely on the other side not finding it. So this is a big deal because it can result in various penalties. And those penalties can be anywhere from, minor stuff to you just lose. So let's have a look at what all is going on here. All right. So defendants, and there's a big list of them, hereby move spoliation sanctions against GWACS Armory. And so they have, various things about what they're doing here, but they note the undersigned has made multiple attempts to resolve this dispute in good faith with Armory's counsel prior to filing this motion. So basically they're saying we reached out and we tried to work this out. We tried to get these documents. We'll see about that too, because that's interesting here. So there's some further sort of details that we'll note here. So on July 20th, 2022, I contacted Armory's counsel, notifying them of the withheld information at issue in this motion, and further requesting to meet and confer as to 1, why Armory had failed to disclose the communications in discovery, and 2, whether there were additional communications that had been concealed in discovery. Unfortunately, Armory's counsel never responded to this request. Now, where I am, and in most jurisdictions, although I will admit I haven't checked Oklahoma, there's usually a duty to respond to the other side. If the other side sends you a communication, you usually have to reply to it. You can't just stonewall the other side. You're required to engage in this kind of back and forth. So that's concerning if they just didn't respond, because this is the kind of allegation or the kind of suggestion that you want to respond to. All right, so on October 18th, 2022, I wrote to Armory's counsel again, notifying them that Armory had withheld additional information in discovery and requested to meet and confer again regarding the issue. As of the date of this filing, however, Armory's counsel has still not responded to this request. Why might they want to not respond to this? Well, we'll get to that. I have some thoughts. So, since Armory has ignored our attempts to confer on the issue, Armory's position as to why it concealed evidence in discovery is still unclear. Now, this is a fair statement when they say unclear. It's suggestive, but I mean, you don't know, right? It's possible that they lost the information. It's possible that it was, deleted by a hacker or something like that. But I mean, when they're turning over some information, but not all the information, it makes us wonder about the nature of the selectivity. So, carrying on. So, memorandum of points and authorities. So, we're going to start with an introduction here, and this is going to lay out. This is I actually really like the writing in this one because it does a good job. It's making my job easier because it's actually explaining the issues in a really clear way. So in any trade secret case, and this is a trade secret case, it is axiomatic that a litigant must preserve all evidence, especially evidence of trade secret disclosure. This is because a trade secret is only a trade secret if A, the person claiming the trade secret has taken reasonable measures to keep such information secret, and B, the information is not readily ascertainable through other proper sources. Thus, once information is made public, it simply ceases to be a trade secret. Now, made public can be in all sorts of ways. I've given the description before of like the structure of a pop can. And there's actually a lot to a pop can, in terms of all of these little bits and shapes and so forth are elements these are design choices that were made for various reasons. One thing that you may not realize is that this aluminum can also has a plastic liner inside to keep the contents from reacting with the aluminum. All of these things are physical elements. And once they sell the first can, they all cease to be trade secrets. Now, there might be trade secrets around them, like how you get the plastic liner to actually, in the can. That method of production might be a trade secret, but the physical shape and the idea of having a plastic liner can no longer be a trade secret because now you've disclosed it by selling even one. So in this trade secret case, Armory concealed critical emails wherein it disclosed the same information it alleges to be secret to third parties. This is huge because, trade secrets are supposed to be secrets, right? It's in the name. It's part of this. And so if you're going around telling anyone who will listen about your trade secrets, they stop being trade secrets. The formula for Coca-Cola is a trade secret, like the recipe for how you make it. If you email Coca-Cola and say, I'm really curious about your recipe, can you tell me how it's made? You'll get back an email saying, very politely, because it'll be a corporate PR person, saying, no, and the politest version of go to hell that they can write down, because they're not sharing that. Because if they do, they may lose the trade secret protection, and that's a problem for them. So, due to Armory's spoliation of this case dispositive evidence, defendants respectfully request that Armory's trade secret and breach of contract claims be dismissed, or in the alternative, that other appropriate sanctions be rendered. So the defendants, KE Arms, Sinistral Shooting Technologies, and so forth, are saying this is so bad that we want to have this case thrown out entirely. Now, they may not get that because that's a big remedy. That's basically it's close to the biggest hammer that the court can swing on this. But I don't know that it's an unreasonable ask. And the reason why is because when they say that this is case dispositive evidence, I don't think they're overselling it here. The details about our trade secrets may not actually be trade secrets. If the court had this information, they might decide, they might have said, hey, you know what? We're just going to throw this case out entirely. We don't think that there is a claim on a trade secret issue if you have disclosed these trade secrets to other people. So, yeah, this is big. This is really big. And this is a massive, massive screw up. This is a massive problem. So in dispositive briefing, Armory vehemently argued that its alleged trade secrets and proprietary information were not publicly known. So, they've communicated this to the court, and that might not be true. It's really a bad idea as a lawyer to communicate something to the court that's not true. And here's the other thing we get to from what we already have in the writing here, which is that it was raised to counsel that they may have communicated to the court things that were not actually true. And usually that triggers an obligation for a lawyer, because let's say, I do criminal defense. Sometimes my clients might be unsavory in some fashion. Let's say that one of them gives me a document that I rely on as evidence, and I submit it to the court believing that it's good evidence, because I would not submit it to the court if I didn't believe it was good evidence. But maybe later I discover that it's in fact a clever forgery, and that I have inadvertently given the court false information. I probably have an ethical obligation at that point to communicate to the court that this information is bad and can't be relied on. That, you have an obligation to correct misconceptions. So this raises a whole lot of interesting issues that if I were on the other side, this is brown trousers time. This is a big deal. Armory's theory is that it never publicly disclosed this information and instead took reasonable measures to keep such information secret by entering into non-disclosure agreements with defendants KA and Brownells. Prior to these motions, however, Armory conveniently withheld communications that establish its disclosure of the same secret information to third parties. And, as we'll see, without NDAs. In fact, it looks like the only people they actually got NDAs with were KA and Brownells. And those NDAs, as I covered in some previous videos, are not super great. But at least they were, something on paper. Immediately after defendants discovered the evidence had been suppressed by Armory, the undersigned counsel requested to meet and confer regarding the issue pursuant to, and this is the local rules. Tellingly, Armory's counsel flat out ignored the undersigned's request. As mentioned, that's not something you do. You just don't. In sum, Armory has flagrantly disregarded its duty to disclose by electing instead to conceal the most significant evidence. And this is like critical evidence because it goes directly to the issue of whether the impugned trade secrets are trade secrets. The extent of Armory's disregard is stunning, and there is simply no excuse for Armory to have withheld evidence that exonerates defendants. Armory's sole claims turn on its disclosure of allegedly confidential information to defendants that was not publicly known. Armory's suppression of critical evidence that establishes the opposite is undeniably prejudicial to defendants. Basically, what they're saying is, at this point, disclosure is done. We've had all of these arguments and so forth, but you withheld this stuff that you were required to give us and would have been fantastic for us. So yeah, because of that, they were basically playing poker without being able to see their own cards. That's a problem. So instead of being able to simply point to Armory's own disclosures, defendants now must attempt to rebut Armory's 11th hour argument that its trade secrets were not publicly known, because basically the window for filing evidence has closed. So they should have had this during that time frame. As a result of Armory's abuse of the litigation process, the court should dismiss Armory's claims as a sanction. As I mentioned, this is a big hammer, and it may not be the hammer that the court chooses to swing, if in fact they, choose to swing any hammer, of course. But I don't think it's an unreasonable ask. Lots of court filings say, we want $10 billion and a pony and for you to personally slap the other side. Like, they make these big asks. This doesn't feel like it's an out of reach ask. But they say, in the alternative, Armory should not be permitted to offer evidence that its trade secrets and proprietary information trade secrets were not publicly known, and this court should instruct the jury to infer or presume instruction that Armory's trade secrets and proprietary information trade secrets were publicly known. Now, I just want to note here that the alternative of, dismiss their claims is basically tell the jury that Armory loses. Which, I mean, seems like dismissing their claims with extra steps. But, again, it doesn't seem like an unreasonable ask. All right, let's get to the procedural background, because they're going to explain how we get there. So Armory's claims in this action arise out of its alleged trade secrets and proprietary information related to a firearm known as the CAV-15, which they say that they have taken reasonable measures to keep secret. And so in discovery, KE Arms requested that Armory produce its internal communications regarding the CAV-15. Armory objected to that, and they had, and I mean, this happens, right? There's back and forth fights over what's going to be turned down. But after several conferences, so they've met before, Armory agreed to substantively respond to the amended discovery request that narrowed the scope to only those communications specifically concerning Armory's alleged trade secrets and proprietary information. But that's all communications involving that. That's what they were required to turn over. All right, so Armory, they got the discovery requests. Armory responded without objection, and they did include communications between Armory's vice president, Shell Jones, but they cherry-picked his communications while concealing others. And this is a thing that's hard to justify when you're asked to do so by a court. Because, you might say, oh, well, we didn't think Shell Jones's communications with anybody were relevant. I mean, that might be an argument you could make, but you really can't say we turned over some of his stuff, but not this other stuff that, turns out to be really super important. This gets to be hard to justify because this starts looking like it could be intentional. Now, there's various reasons why, they might say that it's not. But, if you want to say, hey, this was accidental, typically you would respond to those requests that, that KA Arms and so forth were making and say, oh, look, we screwed up. You're right. These are relevant. We're going to do a further search and we're going to find additional stuff if it's out there. But they didn't do that. So, this might lead to some inferences by the court. Yeah. All right. For example, as set forth below, Armory withheld communications with at least 9 individuals, wherein Mr. Jones freely shared information that Armory now claims to be trade secret and proprietary information in this case. 9. Now, if you're wondering how this came to be, and I mean, I'm just looking and sort of watching this case as an outsider, but KE Arms and Sinistral and so forth basically realized, hey, wait a minute, it looks like these things might not be as secret as they claim. So they put out a call to sort of the public to say, hey, have you had any communications like this? And a bunch of people responded to say, yeah, actually, I asked them about some of this stuff and they turned it all over. So they got this not from Armory, which is where it should be coming from, but from random people out there. And that, of course, means that we don't know how many random people out there are. There's 9 individuals, but there could be 90 or 900 or, we just don't know. All right. So, on June 6th, discovery closed in this matter, and on July 18th, defendants filed their dispositive motions and motions in limine. Armory opposed the dispositive motions, and defendants filed replies in support of their motions. So, they basically were finished doing all the stuff at that point. So, on July 19th, so after the filing, defendants were first apprised that Armory had withheld evidence of communications in discovery pertaining to the CAV-15. Defendants obtained this information through Armory's former customer, whose name I've blanked out just because basically I don't want to be a jerk to that guy, who reached out to KEA online. Now, if you're wondering why would he reach out right the day after, well, things got filed and then people talked about it online and people said, hey, here's this lawsuit. And I'm sure that's how this, this individual found out about this and reached out to KEA to go, whoa, whoa, whoa. You gotta know some of what they're saying is not true. Like, I've got the receipts. So, yeah, I blanked out this person's name, but they are sort of a hero of this story because they're going, we see that an injustice might be happening and we think, we want to step in to deal with that. So thumbs up. That's pretty awesome. The next day on July 20th, so they're not sitting on this. This is not like, hey, we're going to wait in the weeds and, like ambush them with this. This is like, hey, what the heck? The undersigned contacted Armory's counsel, notifying them of the withheld information and requesting to meet and confer as to why Armory had failed to disclose the communications in discovery and whether there were additional communications that had been concealed in discovery. And they just never responded. They ghosted them. Yeah, I mean, you can ghost your ex, but you can't ghost the opposing side when they're coming with issues like this. You just can't. Yeah, this is not Tinder. This is a court of law. In early October 2022, after dispositive motions had already been fully briefed, defendants were apprised of additional communications withheld by Armory in discovery. So, more started coming to light. Once again, instead of receiving this evidence from Armory in discovery, defendants received it from 9 third parties who had direct communications with Armory. And you know what? We're going to see what kind of direct communications there were. And you guys can let me know, let me know in the comments whether you think that these are relevant to the trade secret issues. All right. On October 18th, 2022, the undersigned wrote to Armory's counsel, notifying them again that Armory had withheld information in discovery and requested to meet and confer, and no response, no response, no response. And so, regardless of Armory's intent, the withheld communications are material to the pending dispositive motions as they evidence Armory's own disclosure of information it alleges to be proprietary and not publicly known. So again, there's a question here as to whether they intended to hide this evidence or whether they accidentally hid this evidence. But regardless, like, it doesn't matter why, because this is critical information that blows the case up. Potentially. And by potentially, I mean, we don't know if it actually goes into evidence at this point. So the character of the evidence concealed in discovery. So the known information that Armory withheld in discovery relate to disclosures made by Mr. Jones, Armory's vice president of sales, to third parties. Not only was this information specifically requested by KEA in discovery, the information is highly material to Armory's claims in this case. Further, Armory did not identify these third parties as potential witnesses, which made it impossible for defendants to completely evaluate or identify these public disclosures of Armory's alleged trade secrets and proprietary information. You're required typically to identify potential witnesses to a case. And so this might be a situation where you're like, we don't have the documents, but this is a person who might be a witness. And then they could go and talk to that person and say, hey, what do you know? But there was just nothing, but for these people coming forward independently, there was no way for K Arms or Sinistral or any of them to find these people. That's incredibly damaging, right? Unfortunately, the information set forth below is only the information defendants obtained through third parties that voluntarily came forward with their communications with Armory. Thus, at this point, it is impossible to determine how many other public disclosures were made by Armory and its agents related to the CAV-15. One thing I will note here is that the court process is often not a voluntary process. Lots of witnesses don't want to come to court, but sometimes they have to because they might have relevant information. And had KE Arms had all of this information at the time, one of these witnesses, witness one, for instance, might have said, I don't want anything to do with this. and they could have been subpoenaed. Like, that's the ordinary course of how court goes sometimes, is that sometimes you have to compel a witness to come forward with this evidence. Here they were basically forced to rely on the kindness of strangers. And if you know the context of that quote, that doesn't always work out. All right, so they're going to go through descriptions of these details. So on or about July 15th, 2018, somebody requested an internal photo of Armory's Mark II lower receiver from Armory. Now, this is stuff that Armory says is part of their trade secrets. And so the proper thing to do at this stage would be to just say, no deal. We're not sending that. But they sent an internal photo which shows the internal rib structures and dimensions with a ruler showing dimensional authentication, the design and location of the mold runner, i.e. where the plastic flows into the mold. That's a big deal because they're saying that this is proprietary information. There's some other information that this leaks, and I'll talk about that when we actually look at the picture. The mold gate location and angle, the location of the mold ejector points as shown by the rounded circles on the inside of the plastic product, and other internal details pertaining to the Mark II. So this is enough information in and of itself to produce a Mark II all on your own. There might actually be some questions as to the composition of the Mark II at this point. But I mean, somebody could figure that out. But they've said all of these shape aspects are proprietary and trade secrets. And they just sent it to some random person in an email because they asked. That's not a trade secret. In this case, Armory claims the same information to be proprietary and trade secret, yet they never disclosed these emails in discovery, nor did they identify the person as a witness in discovery. Further, they emailed Armory the following: "That is absolutely what I was looking for. Thank you very much. Have you guys thought about making a second generation lower? I know InRange's What Would Stoner Do project has really pushed the popularity of your receivers. While they're pretty good, as there's definitely some small things I would change, the biggest one being the grip reach to the safety and magazine release. I know it's made like that to give more support to the stock meeting area at the back of the FCG cavity, but could you push the grip forward a bit if you made that whole area just wider / thicker out to the sides? You could even incorporate this modification into having QD socket or other sling mounting points. Thanks again." And so they replied, "We are, and I have passed this on to our engineer for consideration." And in this case, Armory asserts that Armory's vice president, Shell Jones, had the idea of adding a QD sling attachment and ran that idea by Fagan. Once again, Armory withheld this email in discovery. So Armory said this was Shell's idea, and it actually appears it was this helpful stranger's idea. Is Shell claiming credit for stuff from random emails? I mean, and you've got a duty to be accurate when you tell the court things. So, if you're saying that he had the idea, they should properly say that a customer had the idea and sent it on, because that's a big difference, right? When we're talking about trade secrets and so forth, and it's a really big difference between the customer had the idea and passed it on versus this is something that we decided and developed in-house and was known to no other people outside the company. Because that's critical to trade secrets. Yep. Okay. On or about August 23, 2012, a person emailed Armory inquiring about a potential dealer relationship with Armory. On January 15, 2013, Armory replied to them attaching their dealer agreement as well as their technical notes and sales pricing for the Cav 15. In this case, Armory alleges that this pricing information was proprietary or trade secret information disclosed to KA and Brownells under non-disclosure agreements. This witness also received copies of the Cav 15 CAD files, which Armory claims contains proprietary information. Conveniently, Armory never disclosed these emails in discovery, nor did I identify them as a witness in discovery. So just, again, some random company says, "Hey, can I have your stuff?" And they're like, "Here's all the stuff. Here's everything we have." Yeah, this is the equivalent of like, you're supposed to keep your credit card information secret, but instead you just announce it to anybody who happens to ask you nicely over the phone. This is not how you deal with secrets, folks. And this is also why it's a good idea to have a lawyer if you're dealing with intellectual property stuff who can advise you about this sort of thing. And oh, wait, they had one, didn't they? Um, did he not advise them about this? Or, in which case that's not great lawyering, and could create some liability issues. Or did they just ignore their lawyer? I don't know, but something went terribly wrong here. On June 17th, 2017, somebody else emailed Armory inquiring about whether he could customize the length of pull on a Cav 15 Mark II buttstock. And once again, Shell replied, "Cool, attached is a picture of the inside with a ruler. Please don't post this on any public site. I am providing you this so you can succeed with the chop. There is 3 inches of buffer stop, so you only need half of that for 5.56. Please don't post this on any public site is not how you preserve a trade secret. Please. No, you do that with like NDAs and not sending stuff out to random people. In this email, Armory further disclosed pictures showing the internal measurements of the Cav 15 lower, how the lower receivers are constructed, the exact material measurement needed in the buffer tube to support 5.56 ammunition, 1.5 inches, and an internal firewall exact measurement. Notably, these are the same design features of the Cav 15 that Armory claims in this case to derive economic value from not being generally known to anyone who never bothered to ask for them, I guess, because it really doesn't look like they were being all that selective about this. Yeah, it's only known to the universe of people who never bothered to get curious. But again, Armory never disclosed its emails with this person, nor did it identify him as a potential witness in discovery. Yeah, that's bad. That's real bad. On February 9th, 2018, a company emailed Armory asking for technical details regarding the pistol grip on the Cav 15 polymer lower. So potentially a competitor, right? Because this is a company. Specifically, the customer asked for the wall thickness or CAD drawing showing the cavity inside the pistol grip part. On February 15th, 2018, Shell Jones once again voluntarily responded as follows: 0.135 inch thickness on the pistol grip and most other areas. Here's a picture of what's inside. Here again, Armory's attached a picture disclosing the internal measurements, the Cav 15 lower, the internal rib structures and dimensions of the Mark II, the design and location of the mold runner, i.e. where molten plastic flows into the mold gate location and angle, the location of the mold ejector points as shown by the rounded circles on the inside of the plastic product, and other internal details pertaining to the Mark II. Despite the fact that Armory claims this same information to be proprietary and trade secret in this case, it concealed these emails with this person in discovery and failed to identify them as a potential witness, which is going to be a constant refrain. Somebody else contacted them saying, "I would like to reduce the gap, and I will do that better if I know what the lower is made of." So remember how I said pretty much the only detail that was left to know if you wanted to make an exact copy is the material? Well, once again, Shell Jones obliged without reservation, disclosing precisely what the Cav 15 polymer lower receiver is made of: nylon 6 with 20% glass fill. Yet according to Armory, one of its trade secrets is the type of polymer that the Cav 15 was made of, and specifically the same nylon 6 glass material. Now I'm just going to stop here and just note, Armory has scored like this massive own goal here, right? Because right now they're saying that all they've got are all these trade secrets and so forth, and just with these documents, which are now court filings, there is enough information in the public record for anybody to make a Cav 15. Like, a moderately incompetent engineer could knock it, or could build the CAD files and start creating molds to knock out Cav 15s. Potentially anybody out there, and they don't hold any patents. They don't hold any trademarks. They don't hold any of this stuff. So potentially anybody can just start making these. And again, talk to a lawyer because you know that they're litigious and they might sue over that. But yeah. And it's not like, hey, they're filing, stuff that they got via trade secret process. It's via emails to random consumer who exists out in the world. Awesome. So on March 23rd, a person emailed Armory requesting to replace his defective lower receiver. And they noted freely disclosing that Armory has depleted its inventory, which again they were saying was secret information that, that people were using against them. And according to Armory, the number of CAV 15 Mark II lowers it has sold and that they were essentially out of inventory was proprietary and not publicly known. But yeah, they released that. So Shell Jones did a podcast interview. Like this, now we're going to a step beyond, because previously we were talking about like emails that were released and so forth. And now he's doing interviews that are for public consumption and were put on YouTube. Well, I mean, I guess there's a lot about the CAV 15 on YouTube now. In this interview, Armory freely discloses and discusses the manufacturing processes of the CAV 15, as well as Armory's plans to make a telestock/adjustable buttstock model of the CAV 15. This is the same information which Armory claims to be part of the exclusive rights to the CAV 15 IP it purchased from Fagan. So, if this is supposed to be secret, why are you doing public interviews? Like, this isn't just like we answered an email. This is, we did an interview that we knew was intended to be communicated to the public. But they never disclosed that and so forth. I have noticed a couple places where I misredacted, but I'm not going to worry about it at this stage because I don't think it's enough to positively identify a particular individual, but yeah, it's and this is a public document, but I tried. On September 6, 2017, a person contacted Armory and asked any future plans for upgrades, like an adjustable length of pull or built-in QD sockets. Shell disclosed that Armory hoped to launch a next-generation lower that will have adjustability in length and multiple QD sockets. So they never disclosed this alleged idea of using a QD sling attachment outside of the 2015 or 2018 investment packets is what they said to the court, that this was disclosed under NDA, but we have emails that clearly establish the opposite, which were withheld in discovery by Armory. I'm just going to note here, this sentence should have been proofread better, because it actually, the way it's literally written is the opposite of what they mean to say. So there's a proofreading error there, and yeah, I can't fault them too much because I just specifically noted I made my own proofreading errors, but this is an important one for a court filing, and I will mention that that's a problem. They're probably going to have to clarify that in further discussion here. On March 29, 2018, another person contacted Armory and asked about the manufacturing temperature limit. We're getting real specific here, right? After obtaining the technical information from Armory's engineering department, Shell Jones responded 425 degrees is the high temp and it starts to impact the lower. And also specifically mentioned that 300 degrees would be fine. So, yeah. All right, so now they're going to go through the standard for spoliation and what it means. And this is, you're going to see something really rare in the wild, folks. Something that you almost never see. And that is an actual citation to Black's Law Dictionary. I've owned Black's Law Dictionary for a long time, and you don't use it that often. But here's a relevant place. Spoliation is the intentional destruction, mutilation, alteration, or concealment of evidence. And so the court's analysis of claims spoliation sanctions based on concealment or destruction of evidence are the same. Doesn't matter if you hide it. Doesn't matter if you destroyed it. Those are equivalent. So they note that any distinctions between those things are distinctions without difference. A spoliation sanction is proper where 1, a party has a duty to preserve evidence because it knew or should have known that litigation was imminent, and 2, the adverse party was prejudiced by the destruction of evidence. Sometimes people are like, I'm going to get sued, take all the documents to the shredder. And this is the worst thing you can do, because taking those documents to the shredder is spoliation. You have a duty to preserve it because you know you're going to get sued, and you would have had to turn that over. And so now this is the test, right? 1, did they have a duty to preserve it? 2, was there prejudice by the destruction of the evidence? They don't need to show that this was a bad faith decision. So even accidental destruction and so forth. Let's say that every month you take, a box of documents to the shredder because you only keep things for 12 months. Well, if you get sued, you got to stop making those shredder runs. You've got to start keeping that stuff because it might be relevant to the litigation and its documents you have. Somebody going on that shredder run might not be in bad faith, but it might still be spoliation. Again, if you're getting sued, talk to a lawyer, because it can save you a whole lot of headaches. Sanctions for spoliation serve 3 distinct remedial purposes. So this is how they fix things. 1, punishment. So, we want to punish people for doing bad things and thereby encourage others not to do the bad thing. Accuracy and compensation. Sanctions for spoliation may also be designed to promote accurate fact-finding by the court or jury, and this is because, aside perhaps from perjury, no act serves to threaten the integrity of the judicial process more than the spoliation of evidence. When critical documents go missing, judges and litigants alike descend into a world of ad hocery and half measures, and our civil justice system suffers. Let's say there is a confession out there by one company, like they wrote down, we did the wrong thing and we shouldn't have. If they destroy that document, then the court is deprived of considering that when they determine who's at fault. And so that is an attack on the justice system. That's why spoliation is such a big deal. So the standard of review allows, this is part of the inherent power of the court to manage its own affairs and so as to achieve the orderly and expeditious disposition of cases. Courts have a lot of power for determining how court goes, because of course they do, right? There are rules and limitations on that, but they do have a fair bit of power within those. Among those inherent powers is the ability to fashion an appropriate sanction. Sanctions is one of those areas where courts have a lot of leeway. So they have substantial weaponry, pun not intended, I'm sure, in their arsenal to shape the appropriate relief for a party's spoliation of evidence. Or you know what? Maybe I'm wrong. Maybe pun intended. I can't say. So among the options, a court may strike witnesses, issue an adverse inference. And what an adverse inference is that you tell the jury or whoever's making the decision that essentially they should push their finger down on the scale. If you think of the scales of justice, the adverse inference is we're going to push one down and the other up, because essentially that you're drawing a conclusion, right? And the adverse inference here would basically be that the evidence that was destroyed would have been damaging or potentially even fatal to a claim. And adverse inferences can be a really big deal. Impose costs for creating a substitute for spoliated data. As an example of this is, let's say a company goes and shreds all their documents, right? And somehow you manage to recover the shredded documents before they go off to the incinerator or wherever else. And now you have to hire a whole room full of people to sit there with boxes and boxes of shredded documents, reassembling them. That costs money. Like, those people don't do that for free. And so that may be expensive to get people to do that. And the court may say, listen, we now have the documents because they were reassembled. So we can't really do an adverse inference or striking witnesses because we have the documents. But you have to pay for that, right? You have to pay for that process of fixing stuff. This also comes up with like people who delete, delete a hard drive. It might have to get sent off for data recovery, which is not free. Exclude evidence. So sometimes you can prevent people from calling certain evidence and so forth, or in extreme circumstances, dismiss a party's claim. Now, extreme circumstances means that this is going to be a rare remedy, but the places where this might be appropriate is situations where the claim would have to fail but for the evidence. So in this circuit, an adverse presumption that follows the destruction or spoliation of evidence arises only in cases of willful destruction or suppression. So what that means is that one remedy is only available if the court finds that it was intentional destruction. And that's that adverse presumption, right? The presumption that that evidence would have been harmful. This makes sense, right? Because if, let's say the spoliation is purely accidental, right? We were storing all our documents and we put them in a shed to make sure that they would be protected, right? And we locked this shed, we put an armed guard on it and so forth, but unknown to us, the armed guard was kind of bad at his job and, tossed a cigarette and it burned the shed down. All of those documents are lost. But you probably wouldn't want an adverse presumption to apply there that it was these were bad documents, because it was accidental, right? This is the fault of a negligent worker. But if you intentionally go and shred a bunch of documents, like we have been sued, shred everything when they didn't have a shredding policy before, that more suggests that you knew that these were bad documents and that's why you shredded them. Just to provide some explanation there. Ultimately, the severity of a sanction depends on at least two factors: the degree of culpability of the party who lost or destroyed the evidence, and the degree of actual prejudice to the other party. And I feel like here, this second issue is the heavier one, the actual prejudice, because these are very serious. And just as I said that, they go into the severe prejudice to defendants, warrant dismissal of Armory's trade secrets and contract claims. So courts are empowered to impose severe sanctions against a litigant who despoils relevant evidence upon a showing that the conduct prejudiced the opposing party. In the context of trade secrets, courts find the requisite prejudice when the conduct precludes the opposing party from discovering the full scope of the alleged trade secrets, which impedes their ability to obtain evidence relevant to the claims and defenses. And, in some cases, so in this one case, they sanctioned a despoiling party by striking their answer to the claim, dismissing its counterclaim, and entering default judgment as to liability in the movement's favor. So the person who sued, so one side sued the other. The side that was getting sued despoiled a bunch of documents. And so they said, okay, we're striking your defense. We're throwing out your counterclaim. And the other side just wins. That's a huge remedy, right? And so what did they do? They deleted ESI containing the allegedly confidential, proprietary, and trade secret documents. That feels like a direct parallel here, right? The court's dismissal was appropriate because they not only had the responsibility to preserve information relevant to this litigation on the 5 laptops, but that it also had control over those laptops and the information stored on them. And because of the severe prejudice, only a dismissal of claims related to the missing ESI would suffice. And imposition of a lesser sanction would only reward the despoiler for its misconduct in the litigation. And here it feels like that's kind of the same thing, right? Where we're talking about evidence that essentially says that those trade secrets weren't secret at all. They were shared to anybody on the planet who felt like sending an email to Shell Jones. Never tell Shell Jones your secrets, folks. But I mean, Shell Jones is part of the company. He's VP sales. So, I mean, maybe the company has a claim against Jones. I don't know. They'd have to investigate that. But that's not KE Arms' problem. That's not Sinistral's problem. So, yeah. They have another trade secret case in Croomweed and Brighton Associates, which again directly related to the existence of trade secrets. And they say, now here is where I think they do a little bit of a change up. They say, and like here, there was a conscious and deliberate attempt to destroy and cover up conduct. This might be a little too far, given that they have been saying we don't know throughout the filings. Elsewhere in the filings, they say we don't know the motivation, but here they say conscious and deliberate attempt. I agree that the inference seems to be conscious and deliberate attempt, but I feel like this needed more backing up first. That's, that's just a thought. And I know I'm going to have some people going, what do you mean? And I'm going, that's my thought about that. But they found that it had been prejudiced by the spoliation and thus entered default judgment against the despoiler, along with an award of costs and fees. In this case, the prejudice sustained by defendants is immeasurable as a result of Armory's suppression of evidence. Armory's entire claim is predicated on the allegation that its trade secrets and proprietary information were not publicly known. And in fact, if in their original filings, they had said, they disclosed information that we told to anybody who thought to ask about it. And in some cases, they provided way more information than the people actually asked for. The court probably would have tossed that. They probably would have thrown that out a long time ago. So I think that this is a relevant place for saying, hey, we're going to dismiss your claims, possibly with costs and fees. Like, not only are we dismissing your claims, but you got to pay for making this whole court process last as long as you did, when it would have gone away so much sooner had you turned all of this over. So they note that it disclosed and discussed its alleged trade secrets openly with third parties. And yeah, they only obtained this information because these parties voluntarily came forward. And they note, but because Armory concealed these documents and witnesses in discovery, it was impossible for defendants to evaluate or discover Armory's public disclosures. And they note here, the court should consider the extensiveness of discovery in this case. Armory contacted and in many cases deposed each of the witnesses disclosed by defendants in discovery, but defendants didn't get to do the reverse, right? They say now, given the stage of the litigation, the prejudice to defendants cannot be remedied without severe sanctions. They can't go back and depose these people. They can't go and do these things. Further, Armory cannot legitimately dispute the importance of the evidence, nor is there any excuse for withholding the information. I think Armory has already, based on the other documents I've read, Armory has already said that all of these are critical issues and like absolutely essential. Like they've said, these are the crown jewels of our trade secrets, is what they've said in other places, right? And now they're saying, oh, well, now we're finding out that they shared it with everybody. That is perhaps why Armory's counsel never responded to repeated requests to meet and confer. Indeed, this silence speaks volumes. Yeah, I gotta say, that's not the approach I'd take. I mean, if counsel is involved in hiding this, that's a really bad thing. But more likely, I mean, usually lawyers are in a situation where their clients might have done a bad thing. And there you got to manage the client. And sometimes you've got to have a come to Jesus talk with the client. Like, hey, you screwed up. You screwed up real bad. And your screw up has tanked your case. Now the discussion has gone from are we going to win to how much can we mitigate the damage? And yeah. In any event, if a party fails to produce evidence from within its control, evidence that is relevant and material, the fair inference is that the evidence would have weighed against the party who held it back, because otherwise, why would you hold it back, right? If you've got two documents and you hand over one of them and it's the one that's in your favor, the other one that you're holding back is probably something that wasn't in your favor, right? So, yeah, I think that this is a fairly obvious point, quite frankly, that this information is super critical. The strictest of sanctions are required to protect defendant status as innocent parties, safeguard the integrity of the litigation process, and deter misconduct by others. Yep. Armory's culpability is evidenced by its exclusive control and responsibility of the suppressed ESI, so the suppressed evidence. Bad faith or culpability may not mean evil intent, but may simply signify responsibility and control. This can be important. There can be distinctions as to what bad faith means and so forth. Do you have to be a mustache twirling villain, or is it just that it was your job and you didn't do it? Like, these are, and it wasn't like an accident or a misstep or anything like that. Here, where they had exclusive control and they didn't provide it, we can determine that was, an issue there. So defendants need not show that Armory acted in bad faith. Armory's ability to exercise full control is sufficient to establish that Armory acted with bad faith in the spoliation of the evidence. Now, I'm kind of curious about this because this seems like it might be an interesting distinction. Sometimes there's a distinction between bad faith and good faith and the whole gap in the middle, right? And I wonder here where that gap in the middle, which is just like the absence of good faith, I wonder who that goes to here, because I don't know. I'm not local Oklahoma counsel. These arguments seem to suggest that the standard is bad faith, but sometimes you can just have a failure to exercise good faith. It seems to me from reading this, I can infer that's probably not enough for KE Arms, if that's what the court ultimately finds. All right, skipping over, they have a section about lesser sanctions are not appropriate given the stage of this litigation. Now, you might be saying, why are they trying to take tools away from the court here? Like, why, and the idea here is basically, you've heard the saying of when all you have is a hammer, everything looks like a nail. They're trying to make sure that the court only has the biggest hammer in their toolbox and has to choose between either I don't do anything and, they walk, which is a really hard sell in these circumstances, right? This is really bad. Or I have to go for the big hammer because that gets you to the big hammer. You don't want them to use any, smaller hammer. So that's what this whole thing is about, right? They note, in that case, parties were still fairly early in litigation, talking about another one where they imposed lesser sanctions. Whereas in this case, the parties have been litigating for well over 2 years. Discovery is closed, dispositive motions have been filed, and trial is set for next month, right? Like, how do you fix this when the trial is next month? The late stage of litigation warrants severe sanctions against Armory. As mentioned, I would not be shocked if they get them. If the court declines to impose terminating sanctions, defendants alternatively request evidentiary sanctions. Remember how I said they just said the only appropriate tool is the biggest hammer? Well, now they're arguing in the alternative. And this is something really common in law, where you basically sometimes have to say, listen, if you don't agree with the argument I just made, here's another argument you should accept. This is how law works, and it's sometimes something that people find surprising or off-putting about the law. But here they're saying, if you disagree with us that the only appropriate tool is the biggest hammer, how about the second biggest hammer? And so we'll see how they, go about there. So they note here that the court has discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial. Within this discretion lies the power to exclude testimony of witnesses whose use at trial would unfairly prejudice an opposing party. So, for example, I had a trial where the Crown prosecutor failed to disclose a witness statement that was made by a witness. And, this witness was hostile to my client. And the court ruled basically, because you failed to turn over this statement that they made to the police, you can't call this witness at all. Like, this witness is out because it's unfair. How does Mr. Runkle cross-examine this witness when the stuff that he would use to cross-examine has not been shared with him? That's the kind of remedy where they might strike out a witness. And, that's just the fault of whoever failed to provide that. So here they're going to sort of go through. I'm going to speed up a little bit here because, I'm fairly far in, but there's still a bunch of stuff I want to cover here. But they're going to talk about, properly how they could exclude certain evidence or arguments here. So where a critical item of evidence is lost, either intentionally or negligently, the party responsible should be precluded from offering evidence as to its condition. So, this can be an important detail about, you can't really rely on things about hidden, that are hidden information. And I just noted here, this is Tandy Crafts Incorporated. I wonder if that's Tandy Leather. I wonder if that's the same company, because, I do a lot of leather work, so, I don't know about a lot, but I do a fair bit of leather work, so, yeah. Exclusion of inspection notes or other examination material and testimony of any witness based on destroyed evidence was properly excluded as a sanction for spoliation. So defendant spoliator was permitted only to cross-examine plaintiff witnesses and was not permitted to produce any evidence of its own. So, alternatively, they're saying that the court can presume or instruct the jury to infer that communications would have been adverse to Armory. Independent evidence already corroborates those presumptions or inferences. In fact, the stuff that they're filing right now tells us that it was adverse to Armory. In fact, I think fatally adverse to Armory. I actually think that this is not a great remedy because you're giving the jury information here after which the jury can only really draw one conclusion and one conclusion only, which is that these were not trade secrets. So at that point, why do you let the jury decide when there's only one, it seems like the only way the jury could decide that any of these details weren't trade secret, or were trade secrets rather, is jury nullification, which we don't typically allow there. So yeah. If the court were to decline to enter terminating sanctions, this court should presume the spoliated evidence would have been unfavorable to Armory. Again, a missing word. There are some proofreading issues in this. Accordingly, defendants request that the court impose evidentiary sanctions that addressing the public disclosure of Armory's alleged trade secrets and proprietary information. This sentence also goes nowhere. So another proofreading oops. But basically they're saying impose... Yeah, or actually, I think that this isn't a sentence that goes nowhere. I think it's that the ing was accidental, that address the public disclosure of Armory's alleged trade secrets and proprietary information. So, yeah, they request that the trade secret and contract claims be dismissed, or in the alternative, that they strike any testimony from Armory that it never publicly disclosed its alleged trade secrets, and permit defendants to comment on Armory's failure to preserve the evidence, and allow them an adverse instruction, which is that they did disclose it. And they're also asking for fees and costs and any other relief. This is something you always include in a filing. You always put in, court, if you think I didn't ask for enough, if you think you wanted to give me more stuff than I asked for, we also want that other stuff. Whatever other presents you think, it's... If a lawyer wrote a Christmas list, it would be, Dear Santa, I would like a train set, and I would like a teddy bear, and I would like a BB gun, and such further and other relief that Santa Claus might allow. That's how a lawyer would write a Christmas list. I feel like I need to make this a meme and put it up on online. So, yeah. Now, I said, hey, we're going to have a look at the documents. So we're going to do that. As I mentioned, I know this has gotten a little long, so we're going to skim this as fast as we can here, just so that you guys can... I just kind of want to go through this just as kind of a show your work thing, right? Because those were all arguments from, in fairness, those are the arguments of KEA's lawyers. And so, you might say, well, of course they're going to say all this stuff. But how do we know that these documents are actually as damaging as they say? I mean, they're required to be honest with the court, but there's already some allegations of dishonesty with the court, on the other side, or at least insufficient candor, maybe not dishonesty, but that this maybe is something that should have been raised of, hey, this stuff, we've heard that this stuff exists and that therefore some of our representations were not accurate. But let's have a look, right? Let's see, because maybe the documents don't back that up. All right, so this is Costco time. We're checking receipts. So we see that this is a declaration of Russell Fagan. So he's one of the parties. He's making an affidavit. But this is really just a documentary affidavit. He's saying, here's a bunch of documents, and they are true and accurate as far as I know. So we have exhibits 1 through 9. And as mentioned, we're going to skim through these fairly quickly. So exhibit 1, we've got an email here basically saying, I bought one of your lower receivers. I tried finding pictures online of a receiver that split or something, and there doesn't seem to be pictures everywhere of your receivers failing, regardless of what the rumor mill says about polymer. But he does say, is there any way I could be sent a picture of one of your receiver's halves insides before they're welded together? So this is the sort of thing that if this is a trade secret, which again, it really can't be because it's a physical object, anybody could slice one of these in two. But if it were, you would say, we're not sending that picture because it's a trade secret. But no, here's the picture. And you can see at the bottom here, there's this critical bit. And it's not showing my mouse, but that bit just below the pistol grip, that's where the plastic is being injected in. This is the kind of thing that you might otherwise be able to claim is somehow a trade secret because it's not part of the original plastic. But nope, now they're providing that and showing everybody sort of where that goes in and what angle it goes in. And there's some other details that we can get from that, which we'll look at when we got a better picture. All right. So they get a form saying, hey, this is the one that we sort of mentioned before, going, hey, have you ever considered, modifying this? And you could add the QD sockets or other sling mounting points. And they said, we are, and I've passed this on to our engineer for consideration. All right. So, yeah. Carrying on here, just in terms of further exhibits. Thank you for for your interest in becoming a dealer. Also attached is our warranty and technical notes, as well as our 2013 dealer pricing. So here is all of their sort of dealer agreement instruction information and terms and conditions of the agreement and so forth. So this is what you have to agree to if you want to do business with them. Although, from what I understand, they're not making guns anymore, so you can't. But they include their FFL. I blanked out the signature of Mr. Gudgel. Nobody needs that. I also blanked out Shell Jones's contact information because I don't want anybody calling him. But here's their pricing sheet, which they say is confidential and secret information that could only be obtained by, industrial espionage or asking nicely. Yeah. Assembly instructions. So here's a whole bunch of useful information. Technical notes, ways to, improve magazine fit, armor notes, differences between the Cav 15 and the standard aluminum receiver. So parts needed to complete lower, tools for assembly and armor level repair. Yeah. That's useful. Manufacturer's warranty. And yeah. So here's another person that they're sending their dealer pricing sheet to. So there it goes. There's more, stuff on pricing and so forth. Yeah. Have a look here. I have a couple we've cut almost an inch off, so that'd be a 12-inch length of pull. So noting my sister's very short, only 11-inch length of pull. Can the polymer stock be cut shorter without interfering with the built-in buffer? We understand this would involve a fair degree of craftsmanship with hacksaw, file, drill, glue, and screws. Just wanted to know if it's possible. And yeah, they get real helpful here. We'll see just sort of how helpful they get. Another suggestion, if you're into doing the shortening yourself, you can cut 1.5 inch measured from rear, take the butt plate off, top rear towards the front. There's enough material to support operations with a 5.56 or smaller. We have 2.5 inches of material at the end of the buffer tube to support 45 ACP blowback. And yeah, so additional information. They also mention another place that has a cutting service. But we're... So, all sorts of things here. And here is sort of a critical thing they sent along with this. This is a very good picture, with a ruler that shows everything. And critically, we can see that at the 1.5 inch mark, there's that firewall. So it actually marks basically where things can be cut. All right, so Exhibit 4 is where they're saying the 0.135 inch thickness. So that appears to be accurate. And here's a picture of what's inside. Now, this is the best picture we've seen so far, and I think it's the best picture they sent out, or at least that we know of. This shows everything, right? This shows the entire lower. It shows all of the ribs and pins and holes. It gives us a really clear image at the bottom here of the injection point where this goes in. You can see they mentioned, so if you look towards the sort of top left, just below the number 7 recycling thing, there's those circular things. Those are where they're pulling the material out, right? Because all of this stuff flows in, stuff flows out, extra, flows. And the stuff that stays in the mold is basically what you want to keep. This also provides some interesting other information that, they're saying was secret, because they're saying that, it's secret as to the condition of their molds. Well, when you look at this injection point and you see all of that, excess, all that sort of flashing around the edge, all of that sort of extra bit, that's what's telling you that this mold is starting to decay. That this mold is starting to wear out because it doesn't have nice, crisp, clean tolerances anymore. It's not fitting together as well as it used to, and stuff is leaking out. You're losing material. It's requiring extra work to tidy it up. So they're giving away a ton with this, but this is enough for a, combined with what we know about the material, for anybody out there on the planet who wanted to make these, to start making these. And so, this is also where we hear that KE Arms is making a different and better product. Because if all they were doing is, as Cavalry has sort of suggested, is just copying this, there's no way they would want this in the public eye, right? There's no way they'd want anybody to be able to just knock these out and compete with them. Yeah, the fact that they're sending this to just Joe Random tells us they never thought this was a secret in the first place. All right, now we got to zoom in a little bit here just so we can see some stuff. I'm going to try to sort of zoom this in a little bit closer so we can see what all is going on. Exhibit 6. And again, we're going to zoom this in a little bit. So, hello, sorry for the late response. At this time, I don't have the inventory to support an exchange. They were saying that that's secret, that they have no inventory. I'm hoping to have an upgraded model, which we'll look at the exchange rate in the future for you. Please check back in 8 months and let's see where I am at. First of all, I'm just going to note here that this is kind of this is crap service, and I'm just going to come out and say that. Hey, your thing sucked. It failed. I can't do an exchange. This is the point where if you don't have the inventory, you say, you know what, it looks like your thing sucked. I will give you your money back. That's what I'd be doing if I didn't have the inventory to support an exchange. And the other thing I'm going to point out here in terms of like bad service is we'll look at the exchange rate. Like, not when we have a new model, we will just give you another one. We're going to decide how much we're going to give you of a discount off on the new model. That's what that reads to me. I'm sorry, if these parts are like $300. If I was selling these and I sold a defective one, I'd be like, hey, listen, you can have your money back, or in 8 months, we hope to have an upgraded model and we'll just give you one of those. Like a new, yeah, when I had my laptop fail a while back and it was still covered under warranty, the company was like, listen, we don't make that laptop anymore. Here's the new model that we replaced it with, because that's what good customer service looks like. Gee, I wonder why they weren't successful. Yeah. So skimming down a little bit here, so this is sort of somebody who's noting why they sent this out. GWACS is playing anti-gun politics where none is needed. I hope you win and win big. Best of luck to all involved. I think at this point, I certainly agree with that. But noting that the video is still public on YouTube, and they've got the URL here. Now, I'm not including the video in this video because if it's a fellow YouTube content creator, I don't want to poach their stuff. But I'm going to link them. So assuming it's still up, I haven't actually checked that. That'll be something I check when I actually get to posting this. All right. So, and there's also a quote here. Again, I hope you all beat this rich liberal playing games. So, just quoting that. Exhibit 8. Interesting exchange I had with GWACS 5 years ago. They mentioned a next-gen lower with adjustable length of pull and QD points. GWACS never had the lowers back in stock. I checked practically every day for months. It seems by the time InRange published the first of the What Would Stoner Do build series, GWACS had already been sold out for a while. I completed my What Would Stoner Do 2017 rifle with an aluminum receiver instead. Love the new KE lower. Yeah, different discussions where they're saying we're out of stock. I'm hoping to have some FDE next month. Please check back. Which is not honest, because at this point, they knew that their mold was shot. Also, we are hoping to launch a next generation lower that will have adjustability in length and multiple QD sockets. Top secret information that we're sending to everybody who asks about our stock. Yeah. Exhibit 9. I asked them if I could cure moly resin on the lower at 300 degrees without compromising the receiver. And they said, yeah, we'll look into that. At 425 degrees is the high temp and starts to impact the lower. At 300, it should be okay. If it does not work, I will replace yours. This is actually good customer service. I just called them out for some bad customer service. I think this is good. I'm telling you 300 is okay. If 300 turns out to screw it up, I'll fix it. But it's bad trade secret management. I mean, they could have said, hey, listen, we think it'll be fine, but I'll replace yours if it doesn't. Or even just, even if you want to be more cagey, you can say, you know what, we don't know. How about we make a deal with you? You try it, and if it works, great. If it doesn't work, and, I'll replace yours, and you're a product tester for us. Like, you're just trying this out and letting us know, and we'll backstop your test just to... I mean, that would be a better way to preserve your trade secrets. Yeah. So, Yeah. So basically, I think that upon checking the receipts, that those emails are pretty fatal. I don't see how. Um, I mean, I don't see how you bring a trade secrets claim in the face of emails that show that all of this stuff was sent out to the public. Like, I just don't see how you make that claim. But um, here we are. So I will let you know as soon as I have a response to those motions and as soon as we got a decision, because this is a case I'm following. And yeah, um, I'm gonna have some more discussion soon about the Canadian, the new proposed gun bans in C21. So I will have some discussion on that. I'm gonna have some further thoughts. There's a bunch of stuff I'm sort of covering on the go. There's been some Supreme Court decisions I want to cover. But yeah, this was kind of an interesting development, and it's kind of a nice palate cleanser. A lot of the stuff has been really depressing, with the Emergencies Act stuff, with the stuff in C21. This one's kind of funny. Uh, so best of luck to KE Arms and Sinistral and so forth, because I think at this point, I think that this might be it. We might have just seen the end of this case, and I'm hoping we have. Anyway, I want to, at this point, encourage you to do all of the YouTube things, like this video, share it with your friends, subscribe to see more content. All of those things help the channel grow and are much appreciated. I also want to thank my Patreon supporters. There's a link to that in the description below, but at the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At $30, Sights and Arms Limited and Jane Babe and Luxor. And at $20, Mark, Kyle Fox, Haywire, Gerald to the Bailey, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to my $10 supporters who are going to be in the crawl immediately following. Thank you guys for watching, and I hope this has armed you with knowledge.